Welcome, ladies and gentlemen, to our webinar EPO Case Law Update 2020-2021. My name is Matthias Karlhuber. I'm a patent attorney here at Coles & Florak with a couple of years of experience, more than 20 years in that field. Originally mechanical engineer, but currently mainly concerned with medical devices and software applications, and a bit of mechanics still, but that's what I mainly do. And to my right,
Svenja Schwand, nice to meet you and welcome. I'm a patent attorney here at Coles & Florak as well as Matthias, and I basically work in the field of physics, medical physics, for example, and engineering as well. Yeah.
So I said it's going to be EPO Case Law Update 2020-2021, our CF update series. It's going to be engineering, physics, and digital innovations. Just as a quick overview, we'll have an introductory part, or a first part, which is going to be on G1 out of 21, the oral proceedings by video conference. Probably every one of you will have followed. Then we move on to G1 out of 19, which is on the patentability of computer implemented simulations. Then we'll touch upon material and procedural aspects of recent TBA, Technical Board of Appeal decisions. We'll have some procedural aspects under the new rules of procedure of the Boards of Appeal that have come into force in 2020, which have a major impact on how we, well, basically deal with the entire procedure before the EPO. And then at the end of the webinar, we're going to say something about the pitfalls when it comes to transfer priority rights and related case law to that. So let's jump right into it. As said, oral proceedings by video conference, G1 out of 21, something hotly debated, and Svenja is going to tell you something about that decision now.
Thank you so much, Matthias. Thank you. Well, during about the last year and a half, in response to the COVID-19 pandemic and the restrictions on travel and access to the EPO, our proceedings, as you know, were often conducted by video conference. So last year, in the case underlying the G1 of 21 case, the question arose if the conduct of oral proceedings in the form of a video conference is compatible with the right to oral proceedings according to Article 116.1 EPC, even if not all the parties to the proceeding have given their consent. So to the proceeding of the courts, at the very beginning of last year, the parties were summoned to oral proceedings scheduled on June 3rd, 2020, which of course at that time were planned as in-person proceedings. However, after the pandemic outbreak, the respondent, namely the patent proprietor, requested in early May 2020 that these oral proceedings should be postponed due to the COVID-19 pandemic. And thereupon the board informed the parties that the oral proceedings had been rescheduled for February of this year. And in the meantime, in December 2020, a communication of the Boards of Appeal had been published on the website of the EPO, introducing the new Article 15A of the Rules of Proceedings of the Board of Appeal, according to which from January 1st of this year, boards may conduct oral proceedings by video conference, even without the consent of the parties concerned. Well, as the pandemic lasted in January of this year, the respondent again requested that the oral proceedings should be postponed due to the pandemic, in particular in view of travel restrictions from the UK to Germany. And on top of that, he pointed out that the oral proceedings were not suitable for a video conference. Also, the appellant joined and agreed with the respondent, and thus both parties did not give their consent to oral proceedings held by video conference. And nevertheless, the Board of Appeal rejected these requests, and oral proceedings took place on February 8th, 2021, in the form of a video conference. And then during the oral proceedings, the appellant filed a request to refer a question to the enlarged Board of Appeal for decisions as to whether oral proceedings under Article 116 EPC can be replaced by video conference even without the parties' consent. The Board of Appeal in the proceedings then adopted the request and informed the parties that they would refer the question under Article 112 EPC to the enlarged Board of Appeal. Is the conduct of oral proceedings in the form of a video conference compatible with the right to oral proceedings as enshrined in Article 116 EPC? If not, all the parties, that's the key point, to agree to the proceedings. Then in March of this year, then the composition of the panel to decide on the referral case number G121 was determined. And on the same day, the parties of the proceedings, of the prior proceedings, and the president of the EPO, and also a few days later, the public were invited to file submissions and written statements on the referred question. As you may know, this case attracted a lot of attention from third parties, and over 50 amicus curiae briefs and third-party observations were received from various organizations and law firms. The majority of these submissions favored a negative answer to the referred questions. Also, many expressed the view that during the pandemic, holding oral proceedings by video conference without the consent of the parties might be justified. The president of the EPO held the vision and argued strongly in favor of leaving the choice of the former to the EPO or the boards of appeal, respectively, and not the parties. Meanwhile, the appellant filed a partiality objection against the members of the enlarged Board of Appeal due to their participation in preparation of the Article 15A announcement of December 2020, as I just mentioned. And the objections of the appellant were found to be admissible, and the panel in G1 from 21 was recomposed, with the members being replaced by the alternates. Finally, our proceedings were held on July 2nd, 2021. And during these proceedings, the enlarged Board of Appeal reformulated the referred question to point out the specific circumstances of the pandemic, which they refer to as a general emergency impairing the parties' possibilities to attend in person or proceedings at the EPO premises. The board found that the first question to be answered was whether hearing the parties by means of a video conference can also be regarded as holding oral proceedings within the meaning of Article 116 EPC. And for answering the question, the board interpreted the legal text in its wording and found that there is no basis in the word oral for limiting its scope to an in-person hearings in a courtroom. And therefore, the enlarged board concluded that the oral proceedings in the form of a video conference are oral proceedings within the meaning of the EPC. However, the board's further view is that communicating by a video conference, at least for the time being, cannot be put on the same level as communicating in person, which they still refer to as the gold standard. And however, relating to the role of the parties' consent, the enlarged board holds that the parties have a fundamental right to oral proceedings that provides them with the opportunity to be heard. However, parties can be denied the option of in-person gold standard for good reasons. And as for the reasons that would justify denying a party its wish to have the oral proceedings held in person, they made observations that, firstly, there must be a suitable, even if not equivalent, alternative, wherein the board found that even though the limitations of video technology make it a suboptimal format for oral proceedings, this normally is not to such a degree that a party's right to be heard or right for fair proceedings is seriously impaired. Secondly, there must also be circumstances specific to the case that would justify the decision not to hold the oral proceedings in person. Here, they refer to limitations and impairments affecting the party's ability to attend the oral proceedings in person at the EPO, such as travel restrictions. And then finally, the decision whether good reasons justify the deviation from the preference of a party to hold the oral proceedings in person must be a discretionary decision of the Board of Appeal, summoning them to the oral proceedings. Here, the board stated that during a pandemic, delays in finalizing appeals could apply to a great number of pending cases and therefore would seriously impair the administration of justice. So then in conclusion, the enlarged Board of Appeal ruled that oral proceedings before the Board of Appeal can, during a period of general emergency, such as in the pandemic, impairing the parties' possibilities to attend in-person oral proceedings at the EPO premises, be held by video conference, even without the consent of the parties. And now, before we continue with the next decision, we would like to do 2 quick surveys on your opinion to oral proceedings held by video conference. Here's the first one. How do you feel about oral proceedings by video conference? That's what we would like to know. And here we have the choices. I can't wait to get back in-person oral proceedings. Or maybe you're of the opinion that it's okay in the time of the pandemic, even without the consent of the parties. Or maybe you think that oral proceedings as video conference should always be dependent on the consent of the parties. And maybe you are a fan of video oral proceedings and you see that if both parties agree, why not keeping video conference oral proceedings for always as an option? I think we have a lot of.
Yeah, that's an interesting result. So
yeah, I can click on it.
Yeah, at the end of the day, that was a fairly reasonable decision, I'd say, by the enlarged Board of Appeals. They sort of shied away from making a final or giving it a global picture, so they encapsulated it into the pandemic or similar situations, which, as we all know and see, unfortunately, still applies. So I think it is okay. We can live with it. There are certain cases where video conferencing certainly is not the right tool, in my view, but that's my personal view, to use. So that really require in-person hearings. That's how evolution has made us. So we still need that kind of visual contact with each other to get things across. But that's appreciated by the enlarged Board of Appeal anyway. So I would say that is, yeah, it's a reasonable. We can live with it, and it has well, certain advantages depending on how important the case is and on how your budget at the end of the day looks like. So it may, yeah, it's a welcome tool to reduce costs. There's no doubt about that.
Yeah, then we have another survey for you, which might be quite interesting too. Here it is. Maybe you are of the opinion that the German Patent and Trademark Office could take a leaf out of the EPO's book. So maybe you can share your opinion on that one too. As you may know, the German Patent and Trademark Office doesn't help with video conference proceedings so far.
They are not within their scope, in their toolbox so far. Although German courts, for example, use it. So we've seen that. We've been participating in hearings, especially with the Federal Court of Justice, the BGH. So it's live. They use it, and I think it's worth exploring that and using that tool as one of the many tools that we have. Although, me personally, I said I prefer in-person hearings, but anyway, it's good to have that opportunity, especially in cases in days like these.
It seems like most of our listeners see it the same way, and
yeah.
mainly answered yes on the question.
As we see it
Yeah.
And that's pretty much what we would like to see. Okay, good. So that was on that question, on that case. So now we move on to the patentability of computer implemented simulations, G1 out of 19. I'll just give you a quick overview, not go too much into the details. Interesting just to read the claim. If you look at it, it was a computer implemented method for modeling pedestrian movement. It was about the modeling was simulating movement, and that simulation provide a provisional path the pedestrian should walk along. It had a profile for the pedestrian. It had a so-called preferred step, a simulated real step forward for the pedestrian, a cost of taking that step. Quite interesting, and that is a quite interesting feature in there, which basically would helped in deciding would the pedestrian actually take that step or take a different step. It defined a neighborhood, it defined obstructions in that neighborhood, a personal space around the pedestrian, and at the end of the day, it determined whether the preferred step was feasible. And that was it. That was the claim. So the question arose with the TVA or the TBA looking at this. This was in examination. They had doubts as for the technicality of that process, of that claim process, as to what standards are to apply. And they referred those questions that you see in the first place. Can a computer implemented simulation of a technical system solve a technical problem by creating producing a technical effect which goes beyond the mere implementation of the simulation on the computer? Now, it's not just writing the code or dumping the code onto the computer and having it processed. Can it create a technical effect beyond that if the simulation is claimed as such? And interestingly, and you see that picture on the right, which is actually from the decision. So the EBA made a high-level diagram of computer implemented processes. It says, okay, there's an input, there's an output. That may be at the end of the process, there may be during the process, there may be input outputs. That's what you see, the arrows that you see on the above. And then there is a computer implemented process. So there may be something happening, or typically happens something internal to the process. So that's the high level and diagram they use for any computer implemented invention or process. They said, this is what's happening in general. And the question was, okay, if everything just happens inside that box, is it just a simulation that is claimed as such? There is nothing, there is no particular input from any sensors, there's no particular output, at least in the claim. Can the fact that something happens inside the box, inside the simulation, nevertheless have a technical effect apart from it running on a computer? So, and the question then was, if that is yes, if the answer to that is yes, what are the criteria? What are the criteria to decide whether that is such a process, an internal process at the end of the day, solves a technical problem? And a very interesting question that has been asked and then responded to is it sufficient that the system, the technical system that is simulated alone is a technical system? Which you could say, yeah, I'm simulating something really complex and that makes it technical. Let's see what they say. Probably many of you already know it. And then at the final and third question was, what are the answers to that if the simulation is then a part of a design process? So if there is, as you see it on the diagram, if there is at least something on the output side, at the end of the day. So that was the question and the environment that we had. And the EBA gave a very it's worthwhile reading. It's a long decision, but it's worthwhile reading it. View on that, and I'll just get you to the answer straight away. So they say in the answers to the first question, yes, the simulation as such can solve a technical problem by producing a technical effect, which goes beyond just running it on the computer. So as such, okay, it's no problem. There's no problem. You can possibly come up with a technical effect for such something just running inside a computer. Is it for that assessment a sufficient condition? Now, it is not a sufficient condition that the simulation is based on a simulation of the technical principles of the simulated system. So having a technical system that is simulated is not enough to show a technical effect, solving a technical problem. So whatever complex it may be, it is not enough just simulating it, but just describing it and running it on a computer does not do the job in that sense. And at the end of the day, the third answer to those questions, they are no different. They say it's no different whether this is part of a design process or not. It's the standard or that has to be applied in the assessment is no different when there is, well, possibly something of a design process that is then where it is then used. So as I said, just very briefly, a couple of key takeaways. It is a good thing, or the decision is helpful in many ways, that it says computer implemented simulations are as patentable as any other computer implemented invention, as any other computer implemented process. So they do not make a difference for simulations with their specifics in just possibly running just in the box. They say that's not the problem. They appreciate that the technical effects can occur either within the system, at the output, and at the input. So they say, okay, good, there may be something in the overall claimed process, and let's not forget, it's always the claim has to reflect that in some sense, that you can show some technical effects, and we will get to a decision later on where something is it makes that possibly a bit clearer. But at the end of the day, they said we're open. We appreciate that even if internal stuff that runs internal to a computer with no input, no output at the end of the day can still have no immediate output claimed, can still have a technical effect. Nevertheless, and that's the downside or the caveat, you always have to have some direct or indirect link to physical reality. That must always be there. So whether that happens internally, it must have an impact on some physical reality. So it's not that you just running it inside the computer is good enough. It has to have that additional element of, as it says in the decision, it must have that link, directly or indirectly. You don't have to have it necessarily a direct output, and that does then something. Another good thing is that the EBA said, no, we can't really give you specific rules for that. So they shied away, or for a good reason, shied away from saying, yeah, this is the rule and you follow this, and if you do this, then they said that's too complex. And that's a good thing in my view, because at the end of the day, that leaves room for developing that area for having reasonable and up-to-date decisions based on the development of technology. At the end of the day, that's what you need. So that's good in that sense, that it leaves it open. It leaves a lot of flexibility to the case law to develop. As said, I've already said it before, the technicality of the simulated system, another important thing. Just because you have simulating a technical system does not do the job. That's not good enough. So that's been clarified, but that may have also give some steer in that respect. And at the end of the day, the famous convict approach is clearly confirmed by that decision. The convict approach being, you have to have, in order to get technicality of the claim as a whole, you need just one technical element. at the end of the day. But then when it comes to assessment of inventive step, particularly in novelty, it's about, but a particularly inventive step, it's about the technical elements, the technical distinctions over the prior art that are, and only those are considered when it comes to assessing inventive step. That's the convict approach at the end of the day. So a good decision, very interesting decision to read. May have a major impact on artificial intelligence related applications, which are also kind of, a lot of them are in that simulation environment. So yeah, I would say at the end of the day, a very positive, in my view, outcome from the EPO. So do we have a survey then? Yeah,
we have a survey again. Maybe you would like to answer it. The question, what are your prospects for computer implemented inventions after this G decision we just heard about? And you have the choices that it might get even harder, or it, on the other hand, might get easier. Or maybe you're of the opinion that the current situation just doesn't change. So seems to be quite even.
Yeah,
no.
Head on head. But now, okay. Yeah, very interesting. So in my view, I would say, as it confirms the convict approach, especially as it goes to or expands the realm of those computer implemented invention, or says it doesn't treat it any different than a regular computer implemented invention. I would say that's good. It's going to be, well, it's been confirmed that it pretty much stays the same with that level of flexibility that it fortunately gave. Well, less steer, but nevertheless then a bit more flexibility that we have. So I think it's again, it's a very good decision. You can deal with still enough flexibility to try new things possibly. So I'd say I personally appreciate that decision. Good. So let's move on. Another computer implemented invention, technical effect, Article 56 EPC. This is a decision where it was a computerized process was claimed that improves accuracy of billing codes that are provided to health insurance for billing for medical services. So you get a bunch of reports what has been done with the patient, and that is translated basically into billing codes that then go out to the insurance to bill for the medical services that have been provided. Not very surprising to me. The TBA said, yeah, good, that's fine, but all this creation of creating the billing codes and improving the billing codes is just an administrative accuracy. There is no technical effect to that. It's just the end of the day, the bill gets more accurate, or the basis of the bill gets more accurate, but that's it. There is no technical effect to it. It's just implementing the rules that you have that a salesman, a businessman would, the famous businessman would, or administrative person would tell the programmer, yes, could you please do that? Could you please program that? And then, yeah, and if it doesn't work, then do this and this. So even although it was a self-improving, self-learning algorithm, they said, no, it just generates more accurate billing codes, and that's no technical effect. They said there could be a technical effect if there was something technical involved in solving the problem, something inside the computer, something really hardcore technical, let's put it that way. But they said for that, it's they didn't accept it. They stayed to the or they just stuck to the view. Okay, it's an administrative accuracy. You improve the administrative process, but it has no technical effect. So neither the output of that has a technical effect. Yeah, you get a correct bill, but they say it's not a correct, it's not an effect. Nor the accuracy does do anything technical in that sense. So it's a more accurate output in that particular case was not a technical effect, as we sometimes tend to claim. Nevertheless, again, according to the convict process, it was not a matter of technicality. Computerized process was good enough to get across the first convict hurdle to make it technical, the claim. But then the remaining features at the end of the day were non-technical, did not distinguish over the prior art that was there, which already had a computer and running code on it. So they said it's not inventive. Next thing, similar situation. That was a claim where it was about, for a main request, where it was about redesigning a product or process parameter, redesigning the process parameters of a manufactured article based on consumer feedback. So they sent out something, the article, it was diapers in that case, sent them out to the customers, got customer feedback, and redesigned basically the diapers based on the customer feedback. That claim didn't even have anything that made it technical, so that it failed under the first hurdle of the convict approach. There was nothing in there that it didn't say computerized process. It didn't have a processor in it. It just had these steps. And the TBA said, no, there is nothing in there which would even get you across that hurdle. At least one such technical features would be required. Again, convict. And then there was some correlation in that claim, but the correlation as such did also not do it because the correlation was not used in the claim. The applicant amended the claim, and as you see, the last bullet point, it's an auxiliary, the first auxiliary request they filed, and then they introduced a controller that performs the correlation. The result of the correlation was applied to different parameters. Or resulted in different parameters, and they were applied to a converting apparatus. So the red stuff is always the hardcore technical stuff. And then that was, they found, okay, now that is technical. It is it meets the needs, but as the claim was rejected on this non-technicality in the first place, that case was remitted. So we don't know yet what's going to be the outcome. It's basically redesigning manufacturing diapers, sending them out, getting customer feedback, and then feeding that feedback into the manufacturing process. Interesting thing. Think of it. Some of you might have a similar scenario where you might think of doing something. The final CI decision I'd like to talk about is algorithms, and again, convict. As I said, this is the red line that goes through all those computer implemented this convict approach, this landmark decision that we have, this two-step approach. Again, this one didn't have a problem because it was a computer implemented method for classifying emails as spam, with an algorithm which was fairly complex. It hashing, clustering, weighting, and rating the emails. The TBA said, yeah, okay, it's the algorithm as such may have is a non-technical thing, but it may transcend into constraints that are considered in the context of defining the inventive step. So they didn't say that. Forget about it. It's just an algorithm. So they appreciate typically that such algorithms can have a contribution or can contribute to the entire setting of the claim, the entire scope of the claim. They said if the algorithm contributes to a technical effect, could be, then it may be taken into account. They said at one point they appreciated that the algorithm could have actually a technical effect in that it is optimized for the hardware to provide an optimized operation of the hardware. And they said, yeah, we appreciate that could be a technical effect that we would be willing to accept, but the application didn't provide enough disclosure for that. So they said, well, the assumption that this might be the case, that was argued by the applicant, of course, is not good enough. Assuming it is not good enough. So you really have to write something into your patent application, which actually shows, oh yeah, good, this is what I do, this is the specific modification, or this is the specific impact, specifically tuned to my computer system, and not just running standard code on a standard machine. That does the trick, that gets you to the technical effect. So at the end of the day, that's the takeaway from that. You may argue, you may come up with a clever argumentation or some kind of technical effect, but hopefully you don't have to come up with it after you filed the application, but rather you have it in your application. So carefully think of, when already drafting the application, what possibly could you put into that claim in order to come up with later on with an argumentation why this is technical. Good. So now we're leaving the realm of computer implemented inventions. That was a long, quite a bit of information on that, and just a quick excursion to some other things. One interesting decision that we've seen this year is on prior use and confidentiality. Prior use, typically, yeah, as it was in that case, is when it comes to oppositions, and you have to show as the opponent public prior use, or the opponent comes up with public prior use, and the patentee has to deal with it and say, no, that was not public. An interesting relation. It's always, or that often happens. I had that many times, where you have a supplier and a customer, and the supplier typically is bound from disclosing anything that the supplier became aware of, or any possible secret or whatever it is from the client in the cooperation with the client. However, that decision says that the case is slightly different for the supplier. If the supplier has its own knowledge and gives that away, although it is given in the context, but if that is given in the context of something where the customer, the client, doesn't have any particular stake in keeping it secret, then this confidentiality, or this implied confidentiality does not apply. If someone claims that there was confidentiality that goes further, that goes beyond that what is typically used in that context, that requires a bit more. That requires showing that both parties had a corresponding intention, and you have to show that, which is fairly complicated, because typically it's not, well, it may be at your discretion or in your hands to show that, but it's something to keep in mind when it comes to those constellations where you have no secrecy agreement, no written agreement, but just, well, the silent confidentiality agreement. And that is pretty interesting. It's an interesting read when it comes to what is required, especially when there is a joint development. Both have to be aware of the secrecy of this and willing to keep it secret. So it's something that was relevant in that case, and they, at the end of the day, the board found no obligation of confidentiality and remitted the case back to the opposition division. And with that, I had Svenja again.
Thank you, Matthias. Yeah, here we have another interesting case on sufficiency in the mechanical field, you could say. And in the following case, the patent is concerned with a wind turbine with a cooling device inside the turbine tower, which uses outside air for cooling. And according to the appellant in this case, the invention would not be disclosed sufficiently over its whole scope, because Claim 1 covers embodiments that are unable to achieve the technical effect of drawing outside air with a low water and salt content, as explained in the description. In particular, claim 1 named an upper part of the tower, which you can see here in blue. And this upper part comprises an air intake on the left-hand side. And the air intake can be positioned quite low above sea level, as the upper part of the tower, in particular its positioning or its height, was not further specified. However, the TBA did not share this opinion and rather stated, quite interesting, that the argument would misapply case law in the chemistry field, where a claimed invention may reside in a range, but the associated effect may not be proven or plausible for large parts of that range. And then according to the board, a claim in the mechanical field, on the other hand, which attempts to capture the essence of some machine or mechanical structure, is rather schematic, allowing for some breadth of interpretation. Thus, it may be that on clever construction of the claims, subject matter can be found to be covered within the breadth that may not solve the problem or not achieve the desired effect. However, this is normally not an issue of lack of disclosure, but rather of a claim construction. And and the board's view is a skilled person, upon consideration of the entire disclosure of the application, using his common general knowledge, can infer what will and what will not work. A claimed invention is considered to be sufficiently disclosed. That was a key message, I think.
Yeah.
And here in the decision T 1870/16, the implication of the requested referral question by the patent proprietor in accordance with the EPC was the need of the enlarged Board of Appeal to decide the question as to whether or not the conclusion reached in respect of the parent patent in the previous case as regards compliance with Article 123, paragraph 2 EPC has the binding effect of res judicata with respect to claim 1 of the present main request, as these claims are said to have identical scope. This was requested by the patent proprietor. However, the reason for the decision to refuse the request was that the present claim 1 and the claim 1 of the third auxiliary request underlying the previous decision were not of identical scope in the view of the board, because the underlying subject matters and thus the facts were not the same. And the board decided that even if after a decision on the claims of the parent application or the patent, the principle of res judicata applied to the claims of a subsequent divisional application, well, it would not apply in this case for sure.
So they left it open.
They left it open
at the end of the day, which is, well, you can easily think of a situation like that, rather than looking at the scope, at the total scope of the claim. Sometimes, or in many cases, you're struggling for support for a particular feature or feature group, and the question is that disclosed? So you could easily say something the difference in scope relates to something, well, at the end of the day, totally different. So yeah, interesting situation. I can very much imagine that you have those kind of discussions where you've got that an opposition division found support for a feature, or even a Board of Appeal found support for a feature, particular feature, and then does not do that. The next opposition or opposition division or TBA does not find lack of support for that precisely that feature. So I can see why you would want to want to have that decided or not if you're the opponent.
We have a further decision here on admissibility of a strawman opposition. And here the patent proprietor questioned a strawman opposition. He argued that the opposition should not be held admissible because the opponent had no true interest in his view in the opposition. And however, the board, on the other hand, found that case law of the enlarged Board of Appeal in this regard such as, for example, G1 from 2006 or G7 and G8 from 1999, for example, is consistent without contradiction. And the current system of allowing any person to have a patent reviewed by way of opposition proceedings, regardless of any specific interest, is in line with the function of patents to make a technical contribution to society and the public interest in legal certainty and clearing also the register from undeserved broad monopolies, for example. So they stayed with that opinion, and in the next decision here, amendments by new definition was the topic. And there was a major discussion about added subject matter concerning multispectral imaging for identifying an individual here. There were two terms. The term multispectral data was defined in the application and to be understood as a set of all images acquired in one session, wherein the term multispectral image was not defined, but consistent with the standard definition, understood, as they argued, by the skilled person as an image of multiple layers, for example. And then during the proceedings, the board concluded equivalence of the terms as defined in the amended claim, and thus stated that the fact that the definition is new does not automatically mean that there is an extension of subject matter, because the definition would not just be given in a vacuum, but rather in the context of the provided claims and the application as a whole. And also the board found that the corresponding request for amendment of the description during proceedings as a priori regulated by Article 13.2 of the new rules of procedures before the boards of appeal, they considered the request as an exceptional legal situation, because it, on the one hand, improves legal certainty by clarifying the claimed subject matter. And also they had the view that it's particularly in the interest of the opponent and of other third parties, because it may limit the claimed scope, that this would follow the principle that a document has to be interpreted as a whole, and it wasn't detrimental to procedural economy in this case, as all the arguments had already been discussed before, which meant that the board could immediately just decide as to its allowability. And I think we stay here with procedural aspects.
Yeah, we stay with with the boards of appeal.
Right.
Just a very quick roundup. Rules of procedure of the boards of appeal in place and applicable as of January 2020. Strictly applied, to my experience, by most of the boards. We've got this, as we see it here, the 3 levels of convergence. So you've got your first instance decision, then you go to the grounds of appeal, which is already narrow. Could possibly go as broad as the first instance decision. Rarely you get something outside the first instance decision that is virtually unfeasible, and as the diagram shows, and it gets ever narrower what you can do, especially what claims you can file, what amendments you can make. So you've got the grounds of appeal. Typically, you use the requests or something that you had already in front of the opposition division. Let's talk about opposition. Then you go after that. So you state your case. You define your case with the boards of appeal, the appeal case. Then before the summons, it gets ever narrower. So whatever you do after that is already supplied to a narrowing mindset, let's put it that way. And especially once you are post the preliminary opinion of the boards of appeal, it gets very, very narrow. There's hardly something you still get into the proceedings, and it must be convergent, which means it's narrowing of an existing request or something like that. Switching to something different is hardly possible. It's just here. I'm not going into the details of that. It's just a collection of decisions that are given in the context of Article 12, and especially Article 12 and 16 of the rules of procedure. Some of them are really worthwhile reading. It's all about do you have, if you have an amendment to your case, do you have a good excuse for coming up with it now at the appeal stage? That is the key point, which means it's ever harder the further you get, especially after the preliminary opinion of the boards of appeal. The rules say anything that you come up with then should be, and which is an amendment to your case, should be rejected, should not be admitted, except there are exceptional circumstances that allow you to bring that in. So it's a really tough, just a very quick diagram. It's evident. This applies if what you're doing is considered an amendment to your case. So be it as of course, patentee, applicant, an amendment to the claim, but also arguments. If you change your arguments, if you come up with a new argument, you might have, especially as an opponent, a new ground of opposition, for example. That's very hard to get that in. So front load it to the procedure and do it if possible at the first instance. So really, what's changed, what's fundamentally changed over the old days, let's put it that way, is that the appeal, it hasn't been that case even before the new rules came in. So it's been applied very strictly. But the appeal is really a review of the first instance decision. It's not something you can't start from scratch in the appeal. That's not possible. And deal with the first instance decision, especially when you draft your grounds of appeal. That's very important. For the applicant or the patentee, maintain a comprehensive set of requests, file it and maintain it as file positions already in the first instance, because it's ever harder to get it in at the second, at the appeal stage. What we often hear, if for example, if a request has not been admitted by the opposition division, something you possibly file in preparation of the hearing or at the hearing, it's rarely that the TBA says, well, or the other way around, the TBA typically says, well, we can't see any mistake that the opposition division has made in executing its discretion. So you must have a massive flaw in the discretionary decision of the opposition division, which overcomes that primary view of it. They didn't do anything massively wrong. It was their discretion, so we will not admit it either. So be aware of that. Same thing in the other case, opponent, applicants, and patentee. Come up with all your arguments, the good arguments that you may have. Of course, you can't always come up with the right arguments, so that develops over time or develops as the case goes. But think carefully of what you submit already in the first instance, and present your complete case as early as possible. That's really crucial to the entire story, which, yeah, of course, blows up or massively increases the effort for the first instance. So, yep, and a final, well, not so quick one, but we think we should quick.
Yes, I do my best. Yeah, try my best. The last chapter, we'll shortly talk about the pitfalls in the transfer of priority and corresponding case law. And here in the first decision, subject to the proceedings was a European Patent Act application that derived from this international application on the right of two earlier, claiming priority of two earlier applications here, P1 and P2. And the applicants of the priority application, D15 and D16, were, however, not identical to the applicant of the subsequent international application, which was filed here by IRL. And thus the question of valid claiming of priority had to be clarified, because there seemed to be some prior art of Article 54.3 EPC, and under Article 87.1 EPC, the right of priority belongs to the person who has duly filed P1 and P2, or his successor in title. As ARL, however, the applicant of the international application, had obviously not filed P1 and P2, the question arose as to whether ARL in fact was a successor in title here. And while there was no direct assignment of the right of priority of each of the inventors of D15 to ARL, the appellant rather relied on a chain of title here to establish that it is the successor in title of the right of priority from D15. And according to this chain of title, each of the 6 inventors of D15 signed in the year 2000 an employment contract with ARL, wherein, however, ARLs assigned to Alcon University Limited, here AUL, the rights to the invention heretofore and hereinafter conceived. Later then, in 2001, AUL changed its name into Alcon Inc. Incorporated. And shortly before the filing of the priority application P1, ARL entered into a license agreement with Alcon International SA, which here is named AISA. And this license agreement states that AISA has acquired and assumed the economic benefits and burdens with respect to AI's intellectual property ownership, and further provides that any future discoveries shall be the sole and exclusive property of the appropriate R&D principal funding such discovery. And here the appellant stated that ARL was this R&D principal in this case. However, the board found this chain of title unconvincing for some reasons. They stated that the inventors D15 of P1 had signed in 2000 the employment contracts, which, however, assigned to AUL their rights in respect of the invention to be conceived after. And AUL, as I said, then came AI in 2001. And as a result, when the right of priority from D15 came into existence at the time of its filing, this right was automatically assigned to AI. So there was no evidence of transfer or succession in title of the right to priority under Article 87.1 EPC from the applicants of D15 or D16 to the present applicant before the filing of the international application. In conclusion, then, the priority from P1 was not validly claimed, and since the appellant did not submit any evidence regarding the transfer of the right of priority from P2, the finding also applies here. And as a consequence, the document A45 was thus considered prior art under Article 54.3 EPC, and novelty destroying for the opposed patent, obviously.
Too bad.
Too bad.
Too bad. Unfortunately, and don't get me wrong. So we're going to ask a survey later on who can really replicate what we just said, the chain of title. But that is real life. That is real life. I mean, this is a bit much, but at the end of the day, this is something we see not very rarely. So that is that kind of assignment issues or joint applicant issues. They are really a pain, and be aware of that, because as long as there is no opponent, as long as there is no one filing a nullity claim against you, everything is fine. You get your patent, you have a nice little piece of paper that you can hang off the wall. So that's not it. But when it comes to real, and this is the nightmare. You didn't claim your priority properly, and then then some prior art comes in and kills your patent just because the kind of assignments haven't been properly prepared and made. At the end of the day, this is something you tend to neglect because it's, yeah, okay, good, we're going to get that. No, this can really bite you and hit you at the end of the day. Okay, I think we're pretty much there.
Pretty much, yeah. I think so too. Maybe it's one more decision might be interesting, as you may know about the joint applicants approach, which says that in general, this frequent case scenario with US priority applications is that the inventors are listed as the applicant, and then the international application lists the inventors as applicants in respect of US only, and the employer as the applicant in respect for all other states. And this practice is known as the joint applicant approach and affirmed by the EPO. Recently then in Germany, we had a decision of the German Federal Patent Court, which was based on the principle known as the joint applicants approach. And accordingly, it is sufficient if at least one of several applicants of subsequent application is the applicant of the previous application, so that all of them can jointly file a subsequent application, effectively claiming the seniority or the priority of the previous application. And following this, also the German Federal Patent Court, according to them, the international subsequent application on which the ruling was based, which indicated the inventors as applicants for the US and the company as applicants for Europe, among others, can be regarded as joint applicants, and a legal succession of the company already results from this joint subsequent application in such a way that inventors and company can act together as priority beneficiaries. Yeah, I think that was quite recent and maybe interesting for you too,
yes,
even though we're talking about EPO case law.
Mm-hmm.
We have a similar decision here in
Something
Germany.
similar in Germany as well.
Yeah. Right.
Excellent. So, any questions? Do we have any questions? We're happy to take in any questions for a couple of minutes now.
Yeah.
If you wish. So we're waiting for it. So yes, yeah, just a quick roundup. There's been, as I said, those two G decisions in 2021, which created quite some attention, at least in the patent community, I would say. In my view, the EPO in both cases has taken a reasonable approach to that. Video conferencing. Let's put it that way. It's important. It may become important, but it's whether or not it is in person. But in many cases, that's my experience over the past 1.5, almost 2 years, especially with the boards, with the opposition divisions. It's totally feasible. You can do it. It's not my preferred way, but it's a good tool to have. So I'm fine with that. Although I don't like it, and I think important cases, it's still good to present in person, which was also acknowledged by the EBA. Computer implemented inventions. I would say the EPO is on a good and reasonable path. It seems to be one of the, in my view, one of the more receptive and friendly offices when it comes to taking in and appreciating computer implemented inventions. So taking a reasonable approach to it. So I'm fairly happy with that. I'm doing quite a bit. We're doing quite a bit in that field. So that is very good. The rest, yeah. Here now, and then interesting decisions, rules of the procedure of the boards of appeal, really important, a massive impact on how you on your strategy and how you configure and how you structure your cases before the EPO. Already at the first instance has a massive impact, especially in opposition. So be well aware of that, and yeah. That's pretty much it. Oh, the priority thing, also something that doesn't bite you until you really need it. That's the problem with it. It's something you're not aware of, and when it comes to that point, there's in many cases not much to do anymore. So that is the risk with it. So I can only ask you to be well aware of that issue, and yeah, implement the proper process, although it's annoying, but it's at the end of the day, that may save your patent. Okay, so do we have no questions?
I don't think so.
So, but then I would say thank you very much.
Thank you very much.
It was a pleasure having you. Hope you enjoyed it. And yeah, in the name of Koos and Florek, thanks a lot and see you soon. Thank you.
Bye-bye.